buenos días. Estamos en la Facultad de Letras, en el campus del Barrio Viejo de la Universidad de Girona. Y hoy tenemos el enorme placer de tener con nosotros al profesor Ronald de la Northwestern University en Chicago, Estados Unidos. Dará un seminario dentro del máster de razonamiento probatorio que hemos empezado en este año, esta primera edición. Aprovechando esta ocasión, hemos decidido hacer una entrevista respecto de algunas de sus ideas más importantes sobre el sistema estadounidense. El profesor Allen es una de las autoridades más reconocidas en estas cuestiones, en todas las cuestiones que tienen que ver con prueba y el sistema estadounidense o en el sistema estadounidense. No solo en el sistema estadounidense, él ha estado trabajando durante los últimos años en toda una reforma a los códigos procesales en China y Tanzania. Así que es un gran especialista y ha tenido la amabilidad de participar no solamente de nuestro seminario, sino hoy de esta entrevista. Si me preguntasen cuál es el objetivo de la entrevista, yo diría que debería servirnos para conocer un poco mejor el sistema estadounidense. En mi opinión, se han desarrollado y se han hecho públicas diferentes ideas equivocadas sobre el sistema estadounidense, muchas veces solo leyendo las reglas o leyendo a terceras personas que dicen conocer el sistema estadounidense cuando en realidad no han analizado con la adecuada profundidad a este sistema. También hemos tenido una gran, podríamos decirle, problema con todas las reformas, por ejemplo, procesales que se han llevado a cabo, particularmente en Latinoamérica, y que intentan de alguna manera copiar o mirar el sistema estadounidense, haciendo muchas veces trasplantes parciales, dejando de lado figuras que son realmente importantes para un funcionamiento adecuado del adversarialismo. Este es el objetivo de la entrevista. Haré un conjunto de 8 a 10 preguntas en función del tiempo y espero que os resulte de interés. Good morning, Professor. Thank you to be here. We are very glad to having you here. So it is a really great pleasure.
Pleasure's mine. Thank you for inviting me.
Thank you. The interview is about, as you know, as we talk, evidence and proof, your experience as American scholar, and your work in other systems. My whole bunch of questions is like from the civil law systems in order to try to understand a little bit more but not only about your system, but about your own ideas about your systems. So if it is okay for you, we could start with the first one.
It's perfectly fine. I look forward to it.
Great. Well, in your work, there are many papers in which you talk about complexity.
Right.
The complexity of the, not only in the world, but the legal systems. Right. The inadequacy of the tools used by the scholars in order to approach to this complexity.
Right.
So I was wondering if you could explain us a little bit more about this. Let me read some of your ideas about this complexity, which really I think are interesting. You say in one of your works, juridical proof seems so distant from the order lines of other disciplines because the nature of law itself, which provides multiple webs of regulation that encompass most and indeed probably all human interactions.
Right.
Yes. And then you say, one implication of this analysis is that the tools of standard academic research that rely heavily on the isolation and reduction of analytical problems to manageable units to permit them to be subject to standard deductive methodologies may need to be supplemented with analytical tools that facilitate the regulation of complex natural phenomena such as fluid dynamics. So what does it mean?
So there is an increasing recognition that the central challenge of the human condition, and I mean this very, very generally, is what I refer to as the taming of complexity. What I mean by that, and others mean by that, is that the human, a person, whether talking about someone in the legal system or not, is faced with an overwhelmingly complex environment. Our forefathers, foreparents, forebears had to survive in a very hostile environment in Africa. You think of yourself as living in a civilized world, but you're surrounded by all kinds of information that you're constantly having to process. This perspective is emerging in a new science called the science of complexity. The difference between the science of complexity and most of the tools that scholars have used in the past is that it embraces the inability to reduce complexity to single propositions, to simple deductive structures. Now, most academic work from the very beginning is of that sort. Most academic work has tried to deal with complexity by finding a theory, an algorithm. In some areas, that works pretty well. And for example, particle physics, quantum theory, general theory of relativity, these are very powerful theories. But they operate in a system that actually is relatively simple, not relatively complex. When you have a system that's relatively simple, simple deductive structures work well. But when you have a system that is not simple, simple deductive structures do not work very well. And so that's the basic idea that I'm exploring here. The language of modern complexity scientists is that many things that we observe are what we call complex adaptive systems. They're complex because they're complicated, but they adapt to their environment. And if you think about governments, markets, legal systems, from this perspective, all of a sudden you see things a little differently. What a government is, what a legal system is, what a trial is a complex adaptive system. It's responding at the moment it has an input. And so this is a sense of what I'm trying to get at.
Okay, and what about the tools that academic research is using in order to approach these systems?
Well, the primary tools of prior generations are, again, simple deductive structures. You try to articulate a few premises, and then from these premises draw...
Isolated them.
Right, exactly, draw them. It's difficult to reduce complexity science to a simple set of tools, but the idea here is that you're looking at systems not from the perspective of being able to predict every interaction, but maybe understanding the process as a whole.
Okay.
So, for example, take one of the interesting things about complexity and complex adaptive systems is the problem of introducing extraneous variables. What we have learned is why there is one of the consequences of deductive structures, which is that sometimes you write a rule and the rule does not have the effect you want it to have.
Yeah.
Right? Mm-hmm. Well, why? Well, because you write a rule for whatever your purpose is, but then people respond to that rule in unpredictable ways. So this is the idea of emergent properties, that things emerge out of systems in unpredictable ways.
Okay.
So you can think about, if you start thinking about legal systems, about government, you begin to see things in this way. Let me give you some examples. Like, we thought Western society was pretty stable. Well, who predicted Brexit? Right? Who predicted Trump? Now, the language of complexity would characterize those as what we call catastrophes. Not that electing Trump was a catastrophe, or Brexit is a catastrophe in one sense. But what catastrophe means here is you have an ongoing adaptive system, but out of nowhere comes something unpredictable, and then everything reacts to it.
In different ways.
In different ways, in unpredictable ways.
Okay.
Right.
Okay, great. Let me ask you about your American adversarialism. You are, of course, a very recognized scholar in your systems. Nowadays, in our world, almost all the speaking world countries, are some reforms, some changes in the legal systems, trying to make them more adversarial. And there are two main ideas about the American systems that are in play in all that changes, in all that debate. One of them is about the role of truth in the American systems, and people think that you are not interested, your system is not interested on the search of the truth. And the other one, which is sort of quite related with this idea, it is because of the role of the parties. That the parties that you allow, let's say, too much to them, that they manage whatever they want the process in itself. So here you have two ideas which I really like them. One of them about the role of the parties is they are sometimes thought of as ambiguity generators, but in reality they are ambiguity discarders. Rather than litigate an infinite number of ways in which the universe might have been, they focus on a few and ask fact finders to decide which is the most plausible. Right? Then, about the role of truth, you say, the critical point to understand is that the obligation of the court extends to deciding the case correctly based on what the parties have put forth, rather than to decide it correctly for all purposes.
Well, so this is a big question. Let me begin, if I may, by expressing a little bit of frustration with my European colleagues who are less, shall we say, empirically minded than the Americans. That means they talk in theoretical terms, I would say rhetorical terms. And the frustration comes from many well-intentioned scholars repeating things that have been said for a century about the American system as though those statements were true. And here I'm referring to there's an old English judge who referred to the sporting theory of justice and things like this. Yeah. And this is complete and utter nonsense. No modern society, no modern economy can function reasonably well without the promise of relatively accurate and efficient adjudication. Because without relatively efficient and accurate adjudication, then rights are meaningless. So the idea that truth, accuracy, is irrelevant in the American system is absurd. And I wish my European colleagues would realize that and quit repeating these silly things. Now, in comparison between the continental systems and the American system, you have to draw a sharp distinction between civil cases and criminal cases, and they're different. In civil cases, the American conception is that that disputes are private. They have no social interest. So it's you and I are disputing, but that doesn't mean society is at stake. So the role of the government is to be an impartial arbiter, not arbitrator, but arbiter, to allow this dispute to work out. Now, that's in part why some continental theorists say, well, you're not interested in truth. This is just a negotiation between the parties. But here's the point. If the parties have access to information, they know what their case is worth. So if you give them access to information, they are actually going to realize what their economic best interests are, whatever I say economic, but there's whatever their best interests are. And they'll reach an appropriate outcome by negotiations among themselves. If the promise is that if they go to trial, there will be accurate results. Without that, then what I just said won't happen. But if trials promise accurate results, then if I know I'm wrong, it's pointless for me to go to trial.
Yeah, sure.
Because I'm just throwing away my transaction costs, the money I pay lawyers. So that's the American idea. So there's I think some considerable confusion on the continent when they observe the American civil process and what Americans say about it and the role of negotiations and all that. All that happens, but it happens in the shadow of the promise of relatively accurate adjudication. Now, comparing this to the
criminal?
No,
Oh.
to the civil system in Europe, the other aspect of the American system is the economic thought that who knows the dispute? Well, the parties know the dispute. A judge doesn't know the dispute. For a judge, say, in the caricature of the European system, which you can now say I am caricaturing, which you would be right, of the active judge, the judge would have to learn the case as well as the parties to pursue the truth. Well, why? That would double your costs. They would have to the judge would have to spend all kinds of time, all kinds of effort to learn what the parties already know. This seems to us a complete waste of time. And by the way, what it really seems to us is exactly why the theory of the civil systems in Europe is false. The judge will never know the case as well as the parties. So if you look at it from this perspective, what matters is information.
Sure.
That's the key difference between American and continental systems. We make information available. The continental systems make it hard to get. By the way, note how ironic that is. If the continental systems actually pursued truth, what would they do? They would make information as readily available as possible. But yet what they actually do is obstruct it. Discovery is difficult. Privileges are extremely wide. You literally are not able to get lots of information because it's a friend or a family member. So I think the reality of these two systems is not quite what people think. So I don't know if that is an adequate answer. And there were a lot of things we just touched on with respect to the civil system.
Okay, it is. I just have a question, a curiosity. That means that the lawyers has a lot of work to do because the investigation of the
Yes.
facts and blah, 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 blah. What about the education of the lawyers? Would you say that the lawyers in America are like good lawyers?
Yes, they're very good lawyers. But look, there's a range. There are also very bad lawyers.
Yes, sure.
Okay.
As everywhere else.
Remember, the lawyer in the United States becomes a lawyer only after a second advanced degree, which is unusual in the world. You go to undergraduate school in some other field, and then you spend 3 years intensely studying law. In the United States, as you know, the great American law schools are wonderful places of academic research and empirical research, but they're also very practically focused. So almost every single student at my university, Northwestern, studies not just regular courses, but they take what we call clinical courses, where they actually engage in practice under the supervision of good lawyers. So yeah, I think the educational system works pretty well. I mean, it can be better. There are complaints about it. We don't have the same time to produce a lawyer that medical school does to have to produce a doctor, so you don't have as intense practical training, but it's going in the right direction. But can we go back to criminal cases?
Yeah, sure. Please.
Criminal cases are different, and the point I just made about the significance of information for a just legal system, I think is terribly important, but we treat criminal cases quite differently, and I think that's a mistake on our part.
Okay.
We surround individuals with all these constitutional rights. We make it very, very adversarial.
Okay.
The prosecutors and defense counsel, are constantly at each other's throats, we say. And that has the predictable effect of obstructing the pursuit of truth. And it does. But there's a sharp distinction to be made between criminal cases and civil cases. Now, why might we do that? So here's the answer. The central political problem that America tried to solve was what we call the principal agent problem. A principal is the person who hires somebody. Okay. The employee, we call them the agent. You're my agent if you go out and do things for me. The principal wants the agent to do certain things, but the agent has his or her own incentives, okay. Right? Right? So this is the principal agent problem, how the principal controls the agent. Now, in the United States, the foundation of our country was premised upon solving that problem. The fear was a central government, a central government that can aggregate power. But in our conception, and this is true mostly in Europe as well, the government is our agent. We are the principals, and we have to control them, all right? So one way you control them is to make it difficult for them to act. That, by the way, explains what you see in the United States. That's why that explains a federated system with power separated over the states and the federal government. It explains separation of powers. It explains a lot of things. Well, how does this apply in criminal cases? Well, in criminal cases, we didn't want the government to be in a position of easily punishing people. We want to control them there as well. One of the neglected aspects of a jury is that the government in the United States cannot punish somebody unless a randomly selected group of people agree. This acts as a real constraint upon the ability to punish. So it's this dynamic, this underlying dynamic, that is motivating much of our criminal process. And it extends to the over-adversarial nature of it, where it's viewed as a good thing that the defense counsel are doing everything possible to stop the government. At the same time, it obstructs, and it does obstruct, the pursuit of truth. I agree with that. In fact, I've taken the position that our Fifth Amendment to the U.S. Constitution includes, among other things, a clause that says a person cannot be compelled to incriminate himself. And we've interpreted that to mean that they don't have to even answer questions. I think that's crazy. Now, I don't think you should be able to torture people or make them speak, but you should be able to ask them questions and see how they react.
Yes. I have to say.
Right. So, again, going back to your general question, when you think about the American system and the continental systems, first of all, there are many continental systems, not just one, but you have to make a sharp distinction between civil cases and criminal cases. And by the way, I have to say, and I don't mean to be rude here sitting in this lovely city, in this lovely university, but the American civil system works better than any. That's why when people can choose where to litigate in international, they choose London, Switzerland, and New York. London and New York are adversarial systems. Switzerland, the International Chamber of Commerce, embraces adversarialness, but what that means is it embraces discovery. You get access to information. Okay. And if you look at the results are obvious. I mean, with all due respect to Europe, I mean, economic growth in the U.S. always over time, greatly exceeds that of Europe. Innovation is greater per capita than Europe, and I think these are, don't mean to be rude, but I think these are predictable consequences.
Okay. Okay. Well, actually, you have a work about all kind of this stuff, which was translated into Spanish in
the Tarufo?
In Tarufo's conference. Right, yes, exactly. Debatiendo con Tarufo, and there, well, you show all this data that seems to give you the truth.
Well. But there is, if I may, I'm not sure if we're proceeding with this. So there are other issues here, and there may be, I mean, ironically, there may be things that the continent cherishes more than truth. right? I mean, there may be. It may be that they think that, unlike us, that disputes do have a social implication, and you should dampen down disputes. Now, the problem is that makes economic behavior more costly. You have to do business with your friends, and by the way, that's what you do in Europe. There's an awful lot of forming of coalitions and friendships and this and that. That,
From the American perspective.
yeah, that's going to be economically inefficient, but it may serve social purposes.
Okay. Okay. Well, let's continue talking
Sure.
about your system, but with the idea of burdens of proof. In my opinion, your reconstruction about the burdens of proof has a significant explanatory power. About the juridical management of uncertainty. There are different papers from you in which you talk about not only that the burden of proof, the traditional burden of proof, but about the burden of pleading, burden of production, and of course, burden of persuasion. Right. Yes. And you reconstruct your system like let's say like if it were filters, like if every procedural stage was like a genuine filter that people or the lawyers, parties should take their responsibility, for example, showing that they have a case in order to follow the next stage in the procedure. So could we talk about this one? Would you mind to explain us a little bit about those different burdens?
So I think this universalizes, actually. There are three things that a party can be required to do. And that is, number one, plead an issue, that is bring it to the attention of a court. Then number two, produce some evidence to show that there's a serious enough dispute to involve the court. And then number three, you need a decision rule. The decision rule is critical because I don't like universal statements, but even though that was a universal statement, but just about all, if not all, juridical decision, legal decision, is decision under uncertainty. This, by the way, is another mistake I think some of your continental theorists make. You know, you're not supposed to decide, and the judge isn't supposed to decide until he's certain.
Yes, yes.
And now
it's a very generalized mistake.
A very generalized mistake, right? Well, that's silly.
Yes, it is.
Because what it means is either you're kidding yourselves, or you never make a decision. And I think never making a decision is actually pretty indicative of what happens in Europe. Cases just go on for years and years and years. That causes all kinds of problems. Well, in any event, so these are the three things. So you can call them different things, but they exist in all systems. The burden of pleading is just a label for bringing to the attention of a court that there's a dispute to resolve. That can come from the parties, or it can come from the government. When the government goes out and investigates and then files a case, that's essentially an aspect of the burden of pleading. In our system, again, in civil cases, we say these are private. So somebody has to bring to the court's attention that they have a private dispute to resolve. That's the burden of pleading. And whoever wants the court to act has that burden. Once the court knows that there's a dispute to resolve, now the issue that a party thinks there is a dispute to resolve, now the question is there reason to proceed? Somebody has to bring evidence. Again, this is universal, whether it's the government, somebody has to bring evidence. So somebody has the burden to do that, and if they don't do that, they lose. Again, these are actually universal ideas. Having shown through meeting a burden of production that there's a dispute, now you bring all the evidence in and consider it. And at that point, once everybody has said what there is to say, you know what you know, and you now have to apply a decision rule. in the face of uncertainty, how do I decide? And that's what the burden of persuasion does. In civil cases, we talk about preponderance of the evidence, and the reason is if you decide in favor of the more likely, I'd say more plausible explanation, you're going to probably, hopefully, reduce errors over time, and that's the primary objective of civil cases. Criminal cases is different. You're trying to skew errors, make it disproportionate. It's worse to convict an innocent person than acquit a guilty person. By the way, this is beyond probably your questions, but that point that I just went through is now under challenge in Western civilization. That it's worse to convict, it's so much worse to convict an innocent person than acquit a guilty person. And the reason is because of modern conditions of terrorism.
Okay, yes.
When you're talking about even acquitting a murderer who may go free and murder again, that's a terrible thing. But it's not the same as acquitting a terrorist who might go blow up a building and kill 3,000 people. So what we call a Blackstone ratio, what's the ratio? I think is under social pressure, right? So this is beyond, I think, where your questions are going, but you've raised a really interesting question. And you see this, sometimes the language is the language of the trade-off between liberty and security, but that's exactly right. That trade-off is occurring and it's changing in the criminal process, at least in the United States, and I think probably in Europe as well.
Let me talk about the burden of production, because we don't have this burden in our systems, and I think it is quite interesting and maybe related with the discovery that you were talking about, because if you have the possibility to get the whole relevant information for your case, then you could reach this burden.
Right.
If you don't have this access to the information, it is crazy to have this burden.
That's exactly right.
Okay.
That's exactly right. That's very important. Burdens of production are actually pretty meaningless in a system of robust discovery. If everybody has access to all the information, then burdens of production don't matter very much. Because if I don't produce the evidence, you can produce it, it doesn't matter. It's not going to change an outcome. But in a system without access to evidence, burdens of production will determine outcomes.
Yeah, sure.
Right. Sure. If I'm suing you, but you have the information that I need, and I can't get it, and I have the burden of production, I will lose.
Yeah, sure, for sure. Okay, and this burden of production is like it's a decision, a very early decision in the procedure. And for us, for example, like we don't have the discovery, it's like a madness, it's like a crazy decision. How can I decide a case without knowing the relevant information? But I think that there is another issue here, different in our systems, which is the judges' faculties in order to ask for evidence.
Right.
Like they can play these faculties just when the process is running, not at the start, like in your system.
I think that's exactly right. That's point number one. Point number two is that this distinction makes a big difference when you have a judge and a jury. So if judges were just to impose their own views after you've heard all the evidence, and then you would eliminate juries. So you can imagine a case where, having heard all the evidence, I might think the plaintiff deserves to win, but I can understand why somebody else might think a defendant deserves to win.
Okay.
Right? If either side can win, a burden of production has obviously been satisfied, but now, in our system, we have to give that to the jury.
Okay.
So if there can be reasonable disagreements, then we protect the jury system by saying the judge can't decide the case. Now, if there cannot be reasonable disagreements, then it's silly to spend any more time on that trial. And at that point, the judge will end the case. And that could happen at different points throughout our process.
Okay. Okay, in different points, not just in one point.
Right. Right. There's an early a process called summary judgment. What summary judgment allows, almost always a defendant, almost never the plaintiff, after discovery has occurred, well, it's not always after discovery has occurred. At some point, the defendant will say, look, this can't be true. Given, here's what the plaintiff has said. We've taken a deposition where you take a person's testimony, do you know?
Yes, yes.
Here's the deposition. The deposition admits that the plaintiff's own deposition admits that the defendant isn't liable. So trial judge engage in summary judgment, just summarily decide this case.
Okay.
So that can happen at just about any stage. After a plaintiff has offered evidence at trial, the defendant can say to the trial judge, you've heard all the plaintiff's evidence. You don't even have to hear ours. You can see that they have to lose. And if the trial judge thinks no reasonable person could decide otherwise, then he'll issue we call it a directed verdict. You direct an outcome.
Yes.
And after the defendant has closed, the plaintiff can now say, well, you've now heard no reasonable person could disagree. There's no point to waste the jury's time. So it's a means of regulating the information flow and regulating the relationship between the judge and jury.
Yes, sure. And so does this situation could explain why the most of the trials in states, most of the process in a state doesn't end until the endless of the procedure. I mean, they end in a very almost all of them end in a very primarily stage. In this stage, maybe
right.
Not most of them are not here by the jury.
Right. Exactly. And that, by the way, is a good thing.
Yeah, could be I would think.
A legal system.
You don't throw the time or the money.
Right, exactly. If a legal system actually makes the promise of accurate and efficient adjudication, you'll almost never need to go to trial. Mm-hmm. And the reason for that is as people get the evidence, they can appraise the value of their case. If I know what the value of my case is and I know what the value of your case is, now we can settle.
Yes, sure. That's the other point, because the agreement between the parties, it is rational, because you know what kind of information I have, and you know, and we know, and I know what kind of information you have. So I know that if it is perfect to me to make an agreement or not, just to try to win at the end of my case. Exactly.
Right? And you cannot do that without information.
Yeah, sure. It is irrational if I agree without knowing the relevant information.
That's the significance of discovery. So rather than what happens in Europe, as I understand it, is first of all, there are real inhibitions on the ability to get information. You don't have robust discovery rules, and you have very broad privileges. And you can only get discovery by going to hearing after hearing after hearing after hearing, and where the trial judge will say, okay, well, you can do this, you can't do that. And then in another hearing 3 months later, well, okay, now you can do this, now you can do that. And that just makes cases go on forever and wastes all kinds of resources. And at the same time, if you don't end up giving access to all the information, you have no idea if a rational outcome is achieved. Yes. Again, this goes back to the irony of the continent accusing us of not being interested in truth, whereas in fact the reality is you're not.
Well, we don't have the mechanism to get that truth, seems. At least
that's my opinion, but maybe I'm wrong.
I don't think so. I think that I agree in that point with you. But I think that our systems need some mechanism like discovery in order to get all the relevant information at the first stage. As early as possible. Procedure.
Yeah, and that's why evidence law and the field of evidence has to be embedded in the larger procedural context. It's not just rules of relevance or hearsay, but it's the whole shebang. We say the ball of wax, the whole thing.
Yeah, sure. About this whole thing, let's move to the admissibility, to the rules of admissibility, because there's other topic in which people talk about this topic, saying that you have a lot of exclusionary rules and that a whole bunch of relevant evidence is just out of the attention of a judge, of the jury. But it is all because of your exclusionary rules, right? This is one point. The other point is like, it is interesting, at least from my point of view, to discover that you have been put a lot of attention in the admissibility stage, but at the end, for example, the assessment of the evidence that a jury has to make in order to decide a case, it's like the black box for in your system. It's like I don't know if there are data about how actually the judge decide. Well, you have a lot of empirical students with monkey, I don't remember the word exactly. This idea about them, for example, let's see if you were a jury, what would you decide? It is not; they are not actual juries, but simulation. But there is a technical word there that I just don't remember the word. It was like
mock juries.
Mock juries, yes. This is the word, mock juries. And well, this kind of studies could show you something about how people think, but actually you don't know how, in fact, juries are deciding the cases. And this is another difference with our systems. In our systems, there are very few books or people talking about the admissibility stage. It's like, everything just enter in the system. But at least nowadays, there are a lot of people interested in, well, how could we decide? How we should decide a case? And it is interesting, this emphasis in different stages in your world and our world.
I think it's a very intelligent question, combining two different issues: exclusionary rules with the decision-making process of juries. And let me start with the exclusionary side. Again, you have to make a sharp distinction between civil cases and criminal cases. What's often referred to as the exclusionary rule in the United States is non-existent. There isn't an exclusionary rule in the United States. There are hundreds of different exclusionary rules. Put quotes around that term for reasons I'll get to in just a second. And they serve many different purposes, not just one. Let's start with criminal cases, because I think in criminal cases may be more well known than civil cases. So we exclude evidence when the police illegally seize it or when they illegally interrogate somebody. These indeed are not truth conducive. They're not supposed to be. They're supposed to be creating incentives for the government to behave itself. And we explicitly condition the pursuit of truth in this sense on a social value that we think can be as important as accurate outcomes, especially given the fact that these all can only make one kind of error. They can end up acquitting a guilty person, which we don't think of as bad as convicting an innocent person. So it's a one-sided effect, and it's a one-sided effect designed to bring about an important social value, rule of law. And none of those apply in civil cases. They just don't apply at all, period. None of the criminal exclusionary rules. Now, in the criminal context now, we can argue over which is more important, right? Individual convictions or constraining the government. That's fine. People can disagree about that. But it has nothing to do with a disinclination towards truth. It has to do with a recognition, or a belief, I should say, more than a recognition, that government needs incentives to behave itself under our political theory. Remember what we talked about earlier. constraining the power of government. In civil cases, it's a bit different. Again, there's a complete, in my view, misconception on the part of the continental scholars. They talk about these complex exclusionary rules that exist in our rules of evidence, which do govern civil cases as well as criminal cases. And the two examples that are given are primarily hearsay and character evidence, these two complicated exclusionary rules. A little bit the rules about relevancy. But here's my point. Those are not rules of exclusion. Those are rules of admission.
How come?
The hearsay rule in the United States, now I'm talking now about the United States, not the Anglo-American world.
Yes.
The hearsay rule in the United States developed against the background of the English hearsay rule. The English hearsay rule was a serious rule of exclusion. It kept out virtually all hearsay evidence. In fact, the treatises in the 18th and 19th century say things like hearsay is no evidence. I mean, it's quite remarkable. I've looked at all these treatises, actually. Now, it turns out you cannot live in a world without hearsay. Who your mother is, you know because of hearsay.
Yes.
Doctors know most of their knowledge because of hearsay.
Yes.
It's ridiculous. You can't live in a world without hearsay. So the reality of the American hearsay rule is that literally for 200 years, it added exception after exception after exception after exception, with only one possible exception to the exceptions. These have all expanded the admissibility of hearsay.
No, that's it.
Exactly. So now let me just give you some examples. Every single statement that a party makes, including a criminal defendant, whether they take the stand or not, is admissible against that person. That's a huge chunk of hearsay that's now gone. A statement made by a person observing an event, a contemporary observation, it's called a present sense impression, it's all admissible. Business records, admissible. Government records, admissible. I could go on and on and on. You know why? Because there are about 40 of these exceptions, so I could go on and on and on. The reality of the American hearsay rule is that it keeps out only things that are ridiculous, that you'd keep out on relevancy grounds.
Yeah.
Right? Right. Now you might say, well, okay, what about relevancy? You keep things that you exclude things because they're irrelevant. Well, okay, if it's irrelevant, what difference does it make? Because it's irrelevant, right? What you're doing with an relevancy rule, excluding irrelevant evidence, is reducing transaction costs at trial. You have a judge filtering, keeping nonsense out so that one party cannot overwhelm another party. If one party is richer than another party, they can make it too costly for that other party to litigate by just sort of reading the phone book, you know, at a trial, wasting everybody's time. And the relevancy rule says, okay, come on. It's not a game. It's not a sporting theory of justice. Don't do that. The character evidence rule is the same. We say we exclude character, but we end up admitting almost all of it.
Yeah.
So
that's interesting because people here say it's like the paradigmatic example that they raise. Look at the character evidence that they all the time exclude in American trials.
Right.
Yes,
now, it turns out we play games. We play verbal games to get things in, but we play those games. I mean, the rules themselves play those games. So it's not pure, it's not logically sensible, but the effect is to admit almost all pertinent character evidence that you would think would be probative. It almost all comes in.
Okay, great.
Now, the one last point here. We do sometimes exclude, but even here it's overblown, what we call unfairly prejudicial evidence. But again, that's because of the judge-jury distinction.
Okay.
In your system, you don't have lay decision makers. You have professional. Yes. Although you're experimenting. Yes. With, I forget what they're called. Your lay participants in trials.
Jurados.
Yeah, right. So we don't think a trial judge, we don't think is going to be influenced by the horrible picture or whatever, whereas a jury might. We have that distinction that you don't have. But even there, Carmen, the reality is quite different from what it's presented as. Like if a child is shot and killed, and I hate to use a terrible example, but let me give you a real example of a prejudicial photograph. Child shot in the head, and you can see their brains splattered on the sidewalk. And the idea in the continent is, oh, you'd never admit that at trial? You would always admit that at trial. Why? Because it shows the real event.
Okay.
It's not unfairly prejudicial.
Okay. Okay.
Right?
Okay.
So the reality, again, is that what you keep out is nonsense. Now, look, there are millions of trials every year in the United States. So I'm generalizing, right? And if you search through those millions of trials, you will find mistakes.
It is not a perfect system.
It's
like
not a perfect
any system in the world.
It's complex.
Yeah, it is complexity, yes. And what about your black box?
Oh yes, thank you for reminding me about that. Now, so remember the discussion we had a little while ago that it's really interesting to note the effect of a jury, especially in a criminal case. You can't punish anybody unless this group of citizens gets together and deliberates. We want them free to do that. And to a lesser extent, this is true in civil cases as well. To a lesser extent, but to some extent, social norms, community values are taken into account by juries in deciding who should win, where who should win is influenced by norms and values, not just the facts. And if that's the case, the last thing you'd want is you'd want them to come out and explain themselves. You would put pressure on them not to behave in the way you want them to behave, which is to take into account these values. So that's one important component. The second, though, is, look, juries traditionally, although not required, are 12 people. How could 12 people write a memo about how they decided a case? Every single one of them is going to have a different view. They're going to remember different parts of the evidence. They're going to be responding to different parts of the evidence. It's a consensus outcome, but not reached for all the same reasons. There's no way that they could explain their reasoning.
Okay.
Do you understand the point?
Yes, yes, sure.
It's not just one judge who can sit there and rationalize his outcome.
Yes, but we have like some tribunals, some parts of our judiciary that works, let's say, in group, right? They are like 3 judges or 4 judges. They have to reach an agreement, but of course they could explain why they are agree with one decision or another. So I was thinking just like, but I don't know why they can explain us at least the mainly ideas, maybe the mainly evidence, the most relevant evidence that explain why they decide as they decide a case.
Well, you could, but it would be meaningless. My guess is that these opinions that you're talking about are meaningless. My guess is that the judge says, well, these 2 witnesses testified and I believed the first, I didn't believe the second. And the other judges say, yes, that's right. Right? Well, that doesn't explain why. That doesn't explain anything.
It
just describes it. So you could do that, but even here, note, you're not talking about professional judges who do this for a living, right? You're talking about 12 randomly selected people, and it's not 3 or 4, it's 12. And it's exponentially more complicated as you add each person to the list. So, maybe this is not the best justification, but I think it would be impossible to ask a jury to actually explain its reasoning. I think it's impossible to ask a judge. What you get from a judge are conclusions.
In practice, it's like you said, it's just like that. Like they just describe that the expert say X and that the expert is credible or whatever, and they believe X just because of that. Right. They just describe what maybe in happening in their minds. Right. So in practice, it's like that. In theory, they should explain why reach the reasons why they reach a decision.
Right. And I actually think that's almost impossible. I mean, we have this idea that evidence is what's produced at trial, or in your system, not you. I mean, you're going more and more towards a concentrated trial, as I understand it, in Spain. So I'm just sort of generalizing about the continent, but that's a funny view of evidence, because evidence doesn't speak for its own implications. It's a human mind has to hear, see, feel, touch, taste something, and then contemplate it. So evidence really is an interaction between your entire background and what you were observing at this particular moment at time. I don't think anybody can really explain that. You know, why do I think this person's lying and that person's not lying? Well, I mean, it's based on my observations over, in my case, 68 years, but a little hard for me to to pull out all those experiences that I had to explain why I'm generalizing the way I'm generalizing.
Yeah, okay. Well, we are out of time.
Oh, I'm sorry to hear that. I'm having fun.
Yeah, me too. But I want to raise the last question, trying to mix different questions that I wanted to raise. And it is related with all your work in China and Tanzania and these countries in which you were working so hard the last years in their legal reforms, right? Let me see if I can explain. You have this idea about the comparative work, which could be let's say a stupid work to make some people make, because not terribly useful, because you have to know much more about the system in which you want to make let's say a transplant or something like that, and you are very hard with that idea, right? But take care with this idea. Be careful when you are speaking like that. And at the same time, you are doing this job in other countries. So I was wondering, how you did this work? What kind of studies? What kind of group you have to work with all these? This objective to change a criminal legal system in another country. And if I understand right, these countries has a culture or a significant differences with American culture. So it is really interesting for me that having you talking about this whole work.
Yes, so I once referred to comparative work as a comparison of an idealization to a caricature. And an awful lot of comparative legal scholarship is of that kind, that the writer idealizes one system, doesn't see the reality of that system, but idealizes it, and then compares that to a caricature, not the reality of some other system. And that was my complaint about, and in fact wasn't just a complaint, I demonstrated it in the context of Germany, actually. Yes. And the point that I was making, actually the original article didn't refer to caricature and idealization. That was a response to John Langbein's silly rejoinder to my article. The actual title of the first article was a plea for fewer generalizations and more details.
Okay. It's a good title.
Right, exactly.
It's a great one.
Right, and that's kind of the point. You don't want to idealize or caricature. You don't want to deal in rhetoric. You don't want to deal in generalizations. You don't want to talk about the sporting theory of justice because a judge in 19th century England used that phrase. You want to look at the reality of it and then learn what you can learn. Now, that's the background. So in Tanzania, I was hired by the parliament, actually. I was the chief consultant on law reform to the parliament of Tanzania. Still I'm working with them, actually. And consistent with my own admonition, the first 2 years of that project, my team and I spent, the first year in particular, almost exclusively trying to, wrap our minds around the political, social, economic, cultural reality of Tanzania and the history. And so you have to learn the history of colonization, for example. And precisely for the reasons that we're talking about. You're right, you cannot just go to Tanzania and say, look, we have these federal rules of evidence. They're the best thing since, we say in the United States, sliced bread, right? Best thing since sliced bread. Go ahead and adopt them. That's ridiculous. And so we agree, it's ridiculous. Then the second year, after we've wrapped our minds around the reality of the political, cultural, economic, social scenes to the extent we're able to, right? We can't do that perfectly, but we can learn a lot. Then you engage with the legal system and you try to wrap your mind around the Tanzanian legal system from that perspective. Then, after having done that, you can start saying, well, now we have some interesting things to say.
Okay.
Here's what you're doing, as we understand it. Here are the consequences of what you're doing, again, as we understand it. Here's a way that you might think about doing things differently that would avoid those consequences, have these benefits, insofar as we can tell, would be a good thing to do. So it's that kind of an approach in Tanzania. At the end of that, we spent 4 years doing it. At the end of it, we actually did propose to them that they scrap their entire law of evidence. But there's a backstory here. Their law of evidence, although it's called the 1967 Tanzania Evidence Act, it actually is word for word the 1872 Indian Evidence Act. It was transported, talk about a foreign imposition, transposing something from a foreign country. And it was the Indian evidence law imposed in Tanzania by the British colonial masters that Tanzania just kept when it became free. They didn't have any resources. It was not a bloody revolution. They kept their English traditions. So they just changed the names of these laws. And the Indian Evidence Code, I don't have time now to talk about it, but it's a disaster. It's an utter disaster. So it was easy to say this is a disaster. And
you have to prove that it's a disaster.
Right. And you
change it.
Right, exactly. And interestingly, we could provide a lot of evidence about the disastrous consequences of this code. And so then we did recommend a modern, streamlined evidence law that was to some extent inspired by the federal rules of evidence, but it's actually quite different from them.
Oh, really?
Yeah, in my opinion, an improvement on them. I mean, I don't think the federal rules are perfect. And now the status of that is that we made our final proposal to the Supreme Court of the country, called the Court of Appeal, and the Law Reform Commission, and I just got an email 2 months ago, actually, that the project is now being taken up by the Law Reform Commission to be prepared as a bill for Parliament.
Oh, great.
So,
Congratulations.
Well, it's not done yet. And,
almost.
Well, and my guess is what they will do is they will take our proposed code. We actually wrote word for word a proposed code. I'm sure they'll take it and look at the ideas that matter to them, and then reject some others. Yeah, exactly. But I think we're having a positive impact. But to your point, the reason was we did not come in as trying to impose our views from the outside. That was not our point. In fact, from the very beginning, we said the opposite. We said, look, you hired us. We're here to help. And we'll do what we can, but at the end of the day, you do what you want to do, and we'll try to explain what we're thinking, and hopefully it's of value to you. China is different. I have been maybe not at the heart of the reform of the Chinese legal system, but I've been close to it. But that's because 15 years ago, China decided to start sending, like you in a way, you came to be my student, sending students. When I say students, these are faculty at the Chinese universities to study with me at Northwestern. The reason is that during the terrible times from 1961 to 1976, this was called first the anti-rightist movement and then the Cultural Revolution, China, it was a period of madness. I mean, they literally destroyed their cultural institutions, including the legal system. Judges were shot, lawyers were banished, every law school was closed, the books were burned. It's stunning. And of course that destroyed the economy for reasons we talked about earlier today. Without a legal system, you can't have an economy. Sure. So when Mao died, the Chinese Party, Communist Party, thought it faced a peasant revolution. That's why they unleashed economic reform. But then they soon discovered you can't have economic reform without legal reform, and they had shot the judges, banished the lawyers, closed the law schools. And so they began a process of reconstructing legal knowledge in China. That's what I'm involved in. They sent people to study all across the world in different fields. They chose me in terms of the United States approach to evidence, procedure, rule of law, constitutional law. And my students are winning the argument in Beijing. So it's not me writing rules and writing statutes. It's
like in the interaction with people working in their own country.
In their own country.
These legal reforms.
And maybe this is a good topic to end on, because how could I do that in China? Especially when I don't speak Mandarin. In Tanzania, the English is the language of government, so I don't have a language barrier. Well, the reason is that in the field of evidence, not the law, but the field of evidence, there are some things that are universal. There are some things that are not, and one has to make a sharp distinction between them. But cognition, thought, emotion, incentives, the desire for human flourishing, these are universal attributes of the human condition. And much of the law of evidence, the field of evidence, is driven by those universal things, those universal attributes of thought and feeling and emotion. And those apply everywhere. It's out of those that you then say, given our social conditions, now what are the details? How do we want to write a rule that's going to try to accomplish the things we're trying to accomplish? That becomes very local, idiosyncratic. I mean, like our rules are idiosyncratic, they work for us, but they have this backstop of the universal attributes of thought and cognition, and that's the key in China. There, I talk much more about the universal aspects of the field of evidence.
Great. Yes, it is it is a great end of this interview, because we share this idea about evidence, and that's why we are having this program on reasoning on evidence. And so it is a great pleasure to have you here again. And now, well, you have your seminar, and we will be there.
Okay, thank you
so much.
Thank you very much.